My new director looked me dead in the eye across that boardroom table and said, "Neil, if you're not comfortable with where we're taking this division, maybe it's time you considered your options." I remember the exact feeling. Not anger, not fear, something quieter than both. The kind of stillness you find when you've already thought through every scenario and you know exactly what comes next. I'm 51 years old. I spent 23 years in healthcare software development. I built systems that hospital networks across 3 provinces still use today. And the man sitting across from me, my new director, had been in his role for 4 months. Let me back up. I joined the company, a mid-sized health tech firm out of Mississauga, back when it was still called something else. Back when the founders were still in the building and you could actually walk down the hall and talk to someone who understood what the software did and why it mattered. I wasn't a founder, but I was close enough. Employee number 11. I wrote the first version of our patient intake module on my own time, on my own laptop, sitting at my kitchen table in Burlington while my wife put our kids to bed upstairs. That's important. I need you to understand that detail because everything that comes later hinges on it. The company grew. We got acquired by a larger firm based in Toronto in the spring of 2019. Then that firm got folded into a private equity portfolio in 2022. By the time my new director showed up with his MBA and his restructuring plan and his habit of saying bandwidth and synergy in the same sentence, the company I'd joined barely existed in name. His name was Forsyth. That's what he went by. Just Forsyth. Like one name was enough. He came from the insurance sector, which tells you something. He had no background in clinical software, no understanding of what it meant to build tools that nurses and administrators actually depended on, and he had exactly the kind of confidence that grows in people who've never been in the room when something they built breaks at 2 in the morning. Forsyth's first initiative was what he called a talent realignment, which meant he was going to flatten the senior development team, push us into a shared services model, and eliminate what he called legacy redundancies. I was a legacy redundancy, apparently, but before the talent realignment, there was the policy update. It came through on a Tuesday, the kind of gray October Tuesday that feels like it was designed specifically to deliver bad news. An email, company-wide, with a PDF attached. New intellectual property assignment agreement. All employees were required to sign within 30 days. I read it twice. Then I read it a third time. The agreement stated that any software, tool, process, or methodology developed by an employee, regardless of when, where, or on what equipment, that was related in any way to the company's field of operation, became the exclusive property of the company upon signing. Regardless of when, regardless of where, regardless of what equipment. I set down my coffee and I sat very still for a long moment. Then I opened a new browser tab and called my lawyer. I should explain something about my lawyer. His name is Bertrand, and we've known each other since university. He's the kind of person who responds to a legal question with 17 clarifying questions before he'll give you anything close to an answer, which used to drive me absolutely out of my mind. Until I realized that the 17 questions were the answer. Bertrand doesn't miss things. I described the IP agreement to him. I told him about the intake module. I told him when I'd written it, where I'd written it, what equipment I'd used. I told him that the company had been using a version of that module for over a decade, and that it was, at this point, the backbone of their most profitable product line. Bertrand asked me if I'd signed anything when I first joined the company. I had. A standard employment agreement. I'd read it carefully at the time, which was the habit of a younger, more cautious version of me who'd seen enough colleagues get burned to know better. The original agreement had a narrow IP clause. Anything developed using company resources or company time became company property. It was reasonable. It was standard. It did not say anything about work done on personal equipment outside of company hours prior to formal employment agreements about specific products being established. Bertrand asked me if I had documentation. I did. This is the part I want to be honest about, because I think people sometimes hear stories like this and they assume the protagonist had some dramatic masterstroke moment of genius. The truth is more boring and more important. I had documentation because I'm meticulous. I have a folder on an external hard drive, backed up in 2 additional locations that contains timestamped files going back to the early days of that company. Version history, email threads, personal notes, the original development environment logs from my personal laptop. I wasn't saving all of that because I was planning for a confrontation. I saved it the same way some people keep receipts. You never know. Bertrand told me not to sign the new IP agreement yet. He told me to come see him that week. I went on a Wednesday evening after work. We sat in his office in Hamilton and he walked me through the Copyright Act. In Canada, copyright in an original work belongs to the author the moment it's created, as long as the work is original and fixed in some material form. It doesn't require registration. It doesn't require a certificate. It exists the moment you create it. The intake module I'd built on my personal laptop, on my own time, before I had any formal agreement assigning those rights to anyone, I owned it. I had owned it since the first night I wrote it. What the company had was a license, implicit, unwritten, established through conduct over years. They'd used it. I'd let them use it. But I had never formally assigned the rights. The new IP agreement was an attempt to close that gap, to get me to sign over something I'd never actually handed over. I asked Bertrand what happened if I didn't sign. He said that was up to me. He said if I refused, the company would likely view it as non-compliance and use it as grounds for termination. He said if they terminated me, I'd be entitled to wrongful dismissal damages given my tenure. He also said that if they then tried to continue using the module without a proper license from me, we'd have a different conversation entirely. He said it the way he says most things, quietly, looking at his notes, like he was reading a weather report. I drove home that night and I sat in the driveway for a while before going inside. My wife came to the door and looked at me through the glass and I held up one finger, meaning give me a minute. She nodded and went back inside. 23 years together, and she can read that particular signal perfectly. When I came in, I told her what Bertrand had said. She sat at the kitchen counter and listened without interrupting, which is her way. When I finished, she asked me one question. What do you want to do? Not what should you do? Not what are the options? What do you want to do? I want to be clear that I didn't go into what followed looking for a fight. That's not who I am. What I wanted was to do my job well and be treated fairly, which is what most people want. But I also wasn't going to sign away something that was mine because a man named Forsyth needed to check a box on his restructuring plan. I sent an email to HR the following Monday. Polite, professional. I explained that I had some questions about the new IP agreement before signing and that I'd like to schedule a meeting to discuss the details. I CC'd Forsyth and the VP of Legal. The response came from Forsyth directly. He scheduled a call for Thursday, just the two of us, initially, and then he added the HR director, a woman I'd met once at a company event and who seemed, in that brief interaction, to be somebody who understood that her job was primarily to manage liability rather than people. The call was fine in the sense that it was civil. Forsyth explained the policy. I asked specific questions. I asked whether the agreement was intended to apply retroactively to work created prior to any formal IP assignment clause. He said the company's position was that it was a clarification, not a new obligation. I asked who had reviewed that interpretation. There was a pause. He said legal had signed off. I said I appreciated that and that I had some follow-up questions I'd send in writing. After the call, I wrote a careful email. I did not raise the specific module by name. I did not tip my hand. I simply asked, in plain language, whether the company was asserting ownership over intellectual property created by employees before the execution of any agreement assigning such rights, and if so, under what legal basis. I asked for the response in writing. It took them 8 days to respond. The response was 2 paragraphs of legal-sounding language that did not actually answer either of my questions. It was, in Bertrand's word when I forwarded it to him, evasive. He filed a formal notice of copyright ownership with respect to the intake module on my behalf. We sent a copy to the company's VP of Legal via registered mail. 4 days later, Forsyth called me into his office. This is the meeting I started with. the one where he told me that if I wasn't comfortable with where the division was going, maybe it was time I considered my options. I remember the light in that office. Late afternoon, November, the kind of flat gray light that comes through those floor-to-ceiling corporate windows and lands on everything without warmth. There was a little Canadian flag pin on his lapel that I'd never noticed before. The HR director was there, seated off to the side with a folder. I let him finish. I didn't interrupt. I've learned over the years that when someone is delivering a message they've rehearsed, the kindest thing you can do is let them get through it. Interrupting just confuses them and makes the whole thing take longer. When he was done, I said, "I appreciate you being direct. Can I ask whether this conversation is connected to the registered notice my lawyer filed?" He looked at the HR director. She looked at her folder. He said that any legal matters would need to go through proper channels. I said I understood completely and that I had actually engaged those channels already. I told him that I had copyright documentation covering the original development of the patient intake module going back to late 2001, predating my formal employment agreement and any IP assignment clause, and that I'd be happy to provide that documentation if the company wanted to review it. The HR director stopped writing. I told him I didn't want to dispute. I told him I'd been with this company in its various forms for over 2 decades and that I genuinely hoped we could arrive at a reasonable arrangement. I told him that if the company wished to continue using the module under a formal licensing agreement, I was open to that conversation. Forsyth's jaw did something complicated. He said the meeting was over and that he'd be in touch. I went back to my desk. I worked the rest of the afternoon. I went home, made dinner, helped my youngest with a history project about the Confederation, and went to bed at a reasonable hour. 3 days later, I received a meeting invitation from the VP of Legal. Not Forsyth. The VP of Legal. That meeting was different in tone. Considerably different. The VP of Legal was a careful woman named, and I'm using her title because that's how she introduced herself. She was a careful person who spoke slowly and took notes on a yellow legal pad. She asked me to walk her through my documentation. I did. She asked about the development timeline. I walked her through it. She asked whether I had retained legal counsel. I said I had. There was a long pause. She said she would need to review everything internally and would get back to me within 2 weeks. 2 weeks turned into 3. During that time, Forsyth stopped calling me into his office. He stopped appearing in my doorway with what I had come to think of as his alignment check visits, where he would lean against the doorframe and ask vague questions about my engagement with the new direction. Those stopped entirely. When the VP of Legal came back to me, she came with a proposal. The company wished to formalize the licensing arrangement for the intake module. They proposed a retroactive licensing fee, a single payment, and an annual royalty going forward. They would not be pursuing the IP reassignment clause with respect to my prior work. They acknowledged in writing that my prior work predated the scope of the new agreement. I took the proposal to Bertrand. He reviewed it. He said it was reasonable and that the royalty figure was, in fact, somewhat better than he'd expected. I signed it on a Tuesday afternoon in December. There was no ceremony. Bertrand handed me a pen. I signed. He made a copy. We shook hands, and I drove back to Burlington and picked up groceries on the way home. The retroactive payment covered just over 2 years of use at the agreed rate. The annual royalty was structured to adjust with inflation, which Bertrand had insisted on and which I hadn't thought to ask for myself, which is why you have a lawyer. I stayed at the company for another 14 months after that. Forsyth left in the spring. Restructuring, they said, which is what they always say. He was replaced by someone who had actually worked in healthcare IT before, which made an immediate and noticeable difference to the quality of the Monday morning meetings. I left on my own terms. 18 months later, with a standard severance package, a going-away lunch that ran 2 hours longer than anyone planned, and a card signed by most of the development team that I still have in a drawer in my home office. People sometimes ask me, when I tell this story, what the lesson is. I understand the impulse. Stories are supposed to have lessons, especially this kind. Here's what I actually think. I think most people, when they feel threatened at work, respond from a place of emotion. Either they fight or they fold. Both responses are completely human, but neither of them is particularly useful. What helped me wasn't being strategic in some movie villain sense. What helped me was having done the quiet, unglamorous work of keeping good records, reading what I signed before I signed it, and having a friend who happened to be a very thorough lawyer. That's it. No masterstroke. No dramatic confrontation. Just preparation meeting a moment. The intake module still runs on servers in 3 provincial health networks. I receive a royalty statement every March. It's not a fortune, but it's mine. And every time that statement comes in, I think about that flat gray November light coming through the windows of Forsyth's office, and his jaw doing that complicated thing, and the HR director stopping her pen mid-sentence. And I feel something that is quieter than satisfaction and more lasting. I documented the process. The process delivered the result. That's all it ever was.